You guys ready for a double header? Double header? Double header. All right, let's get in there. All right, guys. What up, Leroy? I will say hi to Dan for you is right. I will let him know you said hello. He'll be happy to hear. Just had a good one over in Cranford. Took a 20-minute drive over to Summit, and we're on a double header, baby. It's the second double header in 2 weeks. All right, let's get in there.
Right, so every 10 years, what would happen is the city would evaluate changed circumstances such as Bristol Myers Squibb, if something like that would occur. And then they would calculate their realistic development potential again, and use whatever credits they have, whatever developments that come through the door from developers to create another affordable housing.
So that would be, in other words, the rounds concluded, so maybe 6 years from now, you got a college kid come back to this, well.
Yes, it's every 10 years.
Move on to council questions.
I have a question. Here. Okay. Peter Sabello, 11 Greenfield Avenue. It's not clear to me, on the Bristol Myers Squibb property, what portion of that, or has it been defined yet, on what portion is going to be available for the housing? And that's a big piece of property, I know that.
We're not sure yet. They haven't told us.
That it? Okay. Council questions. You can try. Mr. Gillespie.
Is it just questions?
At this point, the idea is we're gathering questions, sir.
So I have a few. Just to follow up on the whole 25% question. You said that we were not the only municipality who calculated our obligation the way that we did. So is there a consensus among program judges and adjudicators as to how the calculation should occur?
No.
So some of the professionals that try to be appointed to oversee this process actually agree with us.
Yes, there are several special adjudicators and some judges that agree with our interpretation.
Okay. And when you go into a law library and you see all those books, right, there's a winner and a loser for every decision, right?
Yes,
That doesn't mean it's a ludicrous position, right?
that's correct.
And you also said that there's some municipalities who calculated as we did and had their plans approved.
Yes.
As to the question of whether the rounds would ever stop, certainly they could pause for a particular municipality if that municipality has already satisfied their unmet need, depending on whether the rules are changed in the following round, right?
It wouldn't necessarily be paused. So I have several vacant land municipalities who continue to have an RDP of 0 because they continue to have no land to build anything, and the unmet need just gets bigger. And every round, you have to reevaluate your overlay zones and all of the mechanisms that you put in place to make sure they're still reasonable. So there would still be, no matter what, a fight with, and I say that lightly, a discussion, a strongly worded discussion with Fair Share Housing Center on whether what you have in place is reasonable. And that, for me, this experience, it ran the gamut, where they asked for huge increases in density in some towns, and some towns they kept the same as round 3. It just all depended on the municipality, because every municipality is different.
Why does Fair Share Housing have so much power over what any municipality chooses to do in terms of development?
They are the de facto nonprofit entity that looks out for low and moderate income households. And the Supreme Court in Mount Laurel 4 defined them as such. So they are awarded a lot of deference because of the community that they represent.
And if the state legislature so chose to modify the legislation, could it ease the burden on municipalities?
Yes, the Supreme Court, in all of the Mount Laurel decisions, defers to the legislature on how the Fair Housing Act should operate.
So think hard about who you vote for.
Other council questions?
Council President.
Yes, Mr. Boyd.
So how are these areas chosen? How do we even get developers to come in? How does that process work?
Typically, the developer gets an option on property and approaches the city with a project.
So the city's not going out and looking for land to develop on because we're not developers, right? They come to us and that's how this whole thing starts. So the area at Shumpike, once this is signed, the city will own that land, right?
The settlement agreement?
Yeah.
No, so it's going to be transferred, I believe, upon 190 River Road applying for building permits
Got it.
around that time.
So at some point though, they're gonna transfer the land to Summit, right?
Yes.
So Summit will be the owner of that land, right?
Yes.
So can you explain the difference that if the developers still own that land, what the city could say about what they put there, right? So if Russo still owned the property at Shumpike, they could build an apartment building, right? They build pretty much, if it's in zoning, right? They could build.
Well, we have immunity from builder's remedy lawsuits, so they couldn't come in with something that's excessively, dense. At this point in time, that doesn't mean that in round 5, they would use that property to leverage the city in some way, when we do our next plan. If they had kept that property, it wasn't part of our settlement, they could have, gone to the zoning board for whatever application they wanted.
And so now that the city will one day own the property, the city can decide what goes there, right? So for example, right now it's a veterans home. Maybe 2 years from now, the city may decide that we want to put a group home there for disabled children, right? Like, as long as you get to 23 units, right? Is that
25, but yes.
25, right?
Yes, it is, because they're supportive units, it would have to be adults. Because the Mount Laurel doctrine, it doesn't deal with group homes for children, it deals with adults.
No, that's fine.
But yes, so it would have to be, but you would have to at least, we're getting 50 credits out of those 25 units. So, if you built less, or if you built something that didn't amount to 50 credits, and we had,
we would have to find another parcel, right? Like, for example, Bristol Myers Squibb, right? That's 20 units, and we have an excess of 23,
Yes.
right? Okay. All right, so it's better that the city actually owns that property because we have more flexibility in what we can do, right? That's not right, okay.
As of right now, we are required to build 25 veteran-supported housing.
Understood.
That's new.
Understood. The other thing is, Glenwood, Weaver Street, Vita Gala. Look, you don't have to fall on the sword for that one, right? I will certainly take that. And, you know, I'll tell anybody that, you know, every meeting that we had, I brought it up, right? Like, that's what needed to happen. I grew up in this town. I'm familiar with the apartments. Like, I've been in them recently, not like, seen a picture or anything. Like, I actually know people who live there and I go there. So $1 million, right, to help renovate 195 units, and the other structure of the deal where the city will provide legal and counsel and try to get more funds to, you know, submit applications, like the whole process of it, right? I don't think that would have happened without this process, you know, fixing these units. I think that was one of the biggest wins of this whole plan, was renovating 195 affordable housing units, low income, that we have currently in Summit right now that are falling apart, right? This is an amazing thing that we did. The last thing is Westville. Westville did a similar type of deal where they got something from a developer to help offset some costs for affordable housing, right? So,
I think so.
yeah. Yeah. So the idea that this was a gamble, because even the adjudicator said that Summit was fair and did everything. The plan was good. They signed off on it, right? So it wasn't a gamble. And the other idea that you know, there's some various type of deal to get money from retail is absurd, right? Like, we're really not a part of that whole thing, right? I think the great thing is for municipalities to negotiate and actually get something for a developer who's going to develop there anyway is a win-win. Can you explain? I know you said builder's remedy, right? But I think the public is maybe, and I was confused about it at first too, right? So you have an arbitrator, you have developers that come to the arbitrator and say, we want to develop there, right? And then Summit has to say, you can't develop there for a reason. And then they go back to the arbitrator and it's back and forth or whatever, but we can't use our immunity to say no, right? They own that property. So if you could just talk about that sequence of the city's attorney, the arbitrator, fair share, like how did that whole circle work?
I'll do my best. So just for those who don't know what a builder's remedy is, that was created in Mount Laurel 2. That was in about 1985, I believe, 83. Forgive me. There's a lot going on. Mount Laurel 2, because the legislature had not acted since 1975, when the first Mount Laurel decision was created, the Supreme Court of New Jersey took it upon themselves and created the builder's remedy. And what that is if a municipality does not comply and create a realistic opportunity for its fair share of affordable housing in the region, a builder can come in and satisfy that obligation by presenting a project they are ready, willing, and able to develop. Usually, 9.9 times out of 10, that project that they propose is astronomical. It's very dense, knowing that they're going to get whittled down to a number. what also is involved in a builder's remedy is that if a municipality, it's very rare, but if a municipality absolutely refuses to proceed in good faith, there is a remedy where the court can take over your planning board. And the court master, which is now called a special adjudicator, decides what projects are approved and which are not. That occurred in Inglewood Cliffs is the best example of that. That's the shining example of what can happen and what the Supreme Court has allowed courts to do with what they call recalcitrant municipalities. So that's the background of what a builder's remedy is and what the severe consequences are for a municipality. So what happened was, in order to maintain your immunity from builder's remedy lawsuits, the amended Fair Housing Act says you have to meet all of these deadlines. So the first deadline was by the end of January last year, where you had to accept your number or calculate a new number, and then say you were going to abide by this. This is your round 4 number, right? So we did that last year in January. The next deadline is you have to adopt a plan by June 30th, which was the end of round 3. Round 3 was the last day of round 3 was June 30th of 2025, and July 1st started round 4. So your plan had to be in by that deadline. And some municipalities did not do it, and their immunity was stripped and their case was dismissed. Summit, we were fine. We got it all done. Then challengers had to review the municipality's plan and file challenges by August 31st of 2025. That includes Fair Share Housing Center, any developers, any nonprofits. I did have some other nonprofits in certain municipalities that are local that did. We had neighbors, all sorts of challenges were filed. Unfortunately, the Fair Housing Act says a developer cannot challenge your plan and say that my project is better. Unfortunately, the practical effect was the program didn't dismiss those developers, and they got to participate fully in the process. And a majority of the time, I was told, settle with that developer, or we can't recommend your plan. So that's where we were. And like I said, I had other municipalities where I had 350 unit projects that had to go in my plan that I didn't know about until August 1st. Or no, I didn't even know about until August 31st, and they purchased the property on August 1st. So this did not go the way that I think anyone envisioned it would go, unless the developers, they envisioned it, and this is how it worked. So then from August 31st through the end of the year was the time frame in the Fair Housing Act where all the municipalities across the state had to negotiate and settle with any of the challengers if you received any. I had some towns that did not receive any challenges, so which did include the 25% interpretation that I had, and I had no challengers, including Fair Share Housing Center. Just want to add that. So that we've been in mediation this whole time, and mediation is confidential, and that's why we are where we are. Summit has a complicated set of facts, and we had several developers. We had one that we couldn't reach an agreement with. But we had to do things. We agreed with Fair Share Housing Center on how to satisfy our round 4 plan. We received a lot of additional things, particularly from Russo, which helped with the settlement. We received 1.8 acres. It's not easy to come by 1.8 acres of land in Summit and on which to build affordable units. We have $1 million that's going to go toward the housing authority, which is much needed. We have improvements to the golf course that's across the street, because that will de facto become an amenity for that development. order to alleviate the congestion created by this project downtown, which is already congested, I don't have to tell anyone in this room that, Russo is operating shuttle service so that those cars from that project are not going to need parking downtown. He actually, because this is a common request across the state, because parking is difficult, particularly in northern New Jersey where he develops, usually, he actually owns a shuttle service because this is such a often complained about issue for most municipalities. So he is operating that shuttle service for his developments. And that was something that greatly affected the settlement. I hope that helped. Did I answer your question? I don't know if I did.
Yeah, it's okay. It's a whole complicated thing.
Yeah.
It's all good. And the last thing is, what would have happened if we would have disclosed all of the projects that we were doing during this time frame, right? I mean, you just named like 3 different particular periods of the process, and the New Jersey legislature wrote this out, right, so that we couldn't talk to the public. But what would have happened if we did? What were the consequences of that?
It could have compromised either of our settlements. It also could have created an ethical issue for me personally by divulging confidential settlement communications. Usually if you've ever been involved in a lawsuit, you'll see confidential settlement communication written at the top so that it's not a public document, it can't be used as evidence. That is a big issue. And until we knew exactly what was going to be in that settlement agreement, things came in and fell out, and it evolved just about on a daily basis. So there wasn't anything to say until I was required on December 23rd before we had an inked deal with Fair Share Housing Center that was completely finalized. I had to write the brief because I was required by Judge Miller to do so.
Land bank.
Thank you. I have a couple just clarifying questions
Sure.
first. So for Franklin Place, and Augusto gave me some information about this before, but I think it'd be helpful for the public to have.
Sure.
So when we talk about that development, what's the total number of units, not just affordable, that we're gonna plan for that site? Who owns those properties today? When is this development likely to occur? And what are the major gating issues to that proceeding?
Yeah, I'll try to give my understanding of that area and how that evolved and what is going to take place. So, my understanding is that the total number of units that can be produced through new townhouse zoning would be 7. So 20% of that would produce 14 affordable units. I believe it's in that. I don't have it in front of me. I believe the total acreage is approximately 7 total acres, and it encompasses in that block lots 7 through 20. So there's give or take, what's that, 13 parcels or so of varying sizes. Our firm's been involved with Summit for a while in various capacities as city planner, planning board planner, zoning board planner, worked on the DRO, and so we've been deeply involved in zoning development in Summit since I've been at the firm and even prior to my tenure. And this was a site, this area of Summit, Franklin Place, has been identified as a place, sort of a low-hanging fruit, so to speak, that was ripe for redevelopment. In part because of its proximity to the train station, to the downtown. Obviously, the area we're talking about is about half a block to a block just from those areas. So a very walkable part of Summit. And on the westerly side of that block, Franklin Place, where it intersects Summit Avenue, are 2 or 3 new townhouse developments. So the idea, the vision was to continue that development. And those properties are currently in the multifamily / transit-oriented development zone, which in theory, we could have continued down this stretch of Franklin Place, but we wanted to be a little more targeted, a little more sensitive to the existing property owners that are to the north, which are single-family, multifamily, on the north side of Franklin Place. And one of the other thoughts is that what exists between lots 7 and 20 is really a hodgepodge of uses. You have dwellings that include a number of apartments, essentially 2, 3 family buildings. You have commercial uses, industrial uses, and just an area that's evolved in a piecemeal fashion. Over time, there have been a few applications to the, I believe, zoning board for multi-unit projects. There's vacant land there. So again, when we had to think about places where we could produce affordable housing, right? That's the state mandate. That's what we were charged to do. This seemed like a reasonable place to do that. And the program that we thought would be reasonable for that area is townhouse development at 10 units per acre.
Right, but who owns those properties today and when are we planning this development? Is this
So
in
there
time?
are multiple owners of those individual parcels. And again, they're varying in size, varying in use. And so the mandate is to create the opportunity through zoning, so to create the incentive that somebody can take advantage of that and produce affordable housing. So we don't have, the city, no municipality has to go out and pick a developer, has to draw the plans or anything like that. The mandate is that you create the opportunity, and that's what the zoning is intended to do.
Okay, so 70 townhomes on Franklin Place from, it's like Hobart, I believe, over to,
To the corner, so.
yeah, okay. And it's only if the developer wants to do it, okay. On the Summit Housing Authority, just to follow up on Councilman Boyer's questions. So we understand there's $1 million for renovations. My questions are more about like, are there any contingencies with either Fair Share Housing, Summit Housing Authority, or otherwise about how those dollars are spent? Are there additional dollars we need to raise to meet some agreement?
Yes, so, and just for timing for Franklin Place, we have to institute the rezoning by March 15th. By July 1st of 2028, the city will present written commitments to develop the property from a developer in accordance with the zoning, or the city will replace the 14 affordable units with another project. So again, if Bristol Myers Squibb develops with more units, that might be a way that we replace those units if it doesn't come to fruition. So I just wanted to answer your question on the timing on that one. The Housing Authority, there is a 1 million, according to the term sheet that we executed with the Housing Authority, and we will have a more formal agreement before the council at the March 3rd meeting. There is a $1 million payment, lump sum payment, that will be used to start. Is it Glenwood that we have? Glenwood that we have. Yes, Glenwood. They have already done the analysis for what the costs are, so that they can get started with the improvements to Glenwood.
What does that cost?
It's about $175 a unit, $1,000 a unit, $175,000. But there's also they're going to evaluate the other properties to do the same analysis that they did with Glenwood, and then the city is going to provide $180,000 per year to the Housing Authority for specific projects as we go. So through the round. And then by including them in the municipal housing plan, they can then go and leverage funds through the state when they're available to improve those properties. So that's the plan as far as expending money goes.
Okay. And then at our last council meeting, there were some who suggested we completely reject the plan, vote no on the ordinances, etc. So you mentioned before that we must do this or we lose our immunity. Can you just elaborate or comment a little bit further on the consequences of that suggestion?
Yes, so the amended Fair Housing Act says that, like I said, as long as the municipality continues to operate in good faith through this process, it will maintain its immunity. So at this point, operating in good faith is implementing what the city has agreed to. And specifically, there are the ordinances and, adopting the amended plan are the requirements, entering into several agreements, like with the Housing Authority and, an amended agreement with our house and a few developers agreements like that. Those have to be done and submitted to, the program by March 15th. There are other deadlines within, the agreement that we're still, until right before this meeting, we were still negotiating with Fair Share Housing Center, and I'm still waiting for their final revisions. There will be deadlines throughout that we have to meet, either construction deadlines or approval deadlines, or in the case of the veterans projects, we have within a certain, I believe it's within 60 or 90 days of the transfer of the property, we have to rezone, we have to enter into a developer's agreement with whoever's going to develop that project. So within 90 days of the transfer of that parcel. And then 60 days after that, we have to amend the zoning so that it can be brought as a right to the planning board. So there are various things. So all of those deadlines demonstrate that the city is operating in good faith. So if the city is not found to be operating in good faith, whether it fails to adopt all of the ordinances on time and submit them by March 15th, the vicinage judge can remove our immunity.
Okay, so I just wanna make sure I get this.
Yes. It was long-winded answer.
Council has to approve ordinances next month
Yes.
that relate to 190 River Road, Harmon Holdings, Little Kings,
No.
our house, Little Kings is done.
Yeah, Little Kings is before the planning board.
Our house?
No.
Okay, so when is the Our House and Summit Housing Authority, any ordinances related to that? There's nothing, right?
There's no ordinances related to that. Those are agreements.
And then can you repeat what you just said, because I think it's different than what you said to Councilman Boyer about the veterans housing at Shunpike. We have 60 days to do what, after we get that
Okay,
right?
yeah, let me get the exact. Let me just find it. So I'm saying that.
There are residents from that neighborhood here too, I just wanna make sure.
Okay, yeah, sure. Okay. Russo will donate property known as 47 and 53 Shunpike, to the city for a municipally sponsored 100% affordable veterans supported housing project. The agreement between the city will require the property be transferred to the city in accordance with the terms of the mediation agreement with Russo. And Russo has agreed that it shall deed Shunpike to the city with clean title upon obtaining final unappealable site plan approval from the planning board. I'm sorry, I did say building permits before, but it's as soon as they have unappealable approvals from the planning board for their project. Within 90 days of receipt of the recorded documentation transferring Shunpike to the city will enter into an agreement with the developer of the veterans project and provide an executed copy of the agreement to Fair Share. It will include a pro forma of construction costs and a plan for those construction costs. Within 60 days of the execution of the agreement, the city shall rezone the property to ensure that the developer can proceed as of right with a site plan application to the planning board. So those are the deadlines for that one.
So we have a very short window, if that at all, to change. I'm confused, because you just said we didn't have to put it there.
I didn't say.
Okay.
So we have to develop that property with supportive housing.
Okay,
Yes.
but it doesn't have to be the veterans housing.
It doesn't, but that was the intention. We have to develop it with supportive housing because
I
there's
understand
50
that, but
credits.
I just want to clarify whether or not it's required that we put veterans housing there.
It's not, but that was the intention.
That's-
I'm so sorry, yes.
Yes,
Council.
maybe just to follow up to that, if disagrees with the Shuttle Pipe project siting and use, is there an opportunity to move it somewhere else in the city to a different location or a better location? Is that something that we have the power to do?
Not really, no. This was the agreement that we entered into, and we would have to amend our plan, and go through this process again.
Yeah. So,
Okay.
what does that mean?
Firing rate.
When you say we have to go through amending the plan, what does that look like?
Well, we have an agreement with Fair Share Housing Center. We have a recommendation for an approval for this project. So,
No,
this is,
Let- one person at a time, and at this point, it's Ms. Hall.
I don't recommend doing any of that. We'll just put it that way. I don't think that's a good idea.
Please don't shout, not.
Council President, I had additional questions, but
Keep going.
that's different from my understanding when I was here before as well. So I understand that people are confused. I didn't understand. But we're all digesting this information, which is very new for all of us. Going back to your question about other towns, why were other towns around us, like Westfield, which is not Summit, but it is a wealthier town, how were they able to have a more open and transparent process? And what did they do differently that allowed them to have more visibility and more openness with their community members?
I'm not familiar with Westfield.
I don't know all of the details, but I know one of the attorneys that was involved. My general understanding is that they were able to resolve the various disputes from the developers interested in certain projects, which were, my understanding is small in scale and a bit more palatable for the community. So they're able to approve those amicably prior to the challenge process. So they essentially went into the challenge period, basically hand in hand with Fair Share Housing Center, with a plan that worked for everybody. Summit, we obviously had a few challengers. We're going to the challenge period. We knew we would be facing those challenges, and at that point had not reached agreements as far as what the city might deem to be, acceptable scale development.
A question I think perhaps best suited for you, Tom. I'm wondering whether the projects within the affordable housing agreement are compliant with Summit's current master plan, especially the 190 River Road project, which to me looks to be outside the master plan's parameters. And if you have any information overall, in particular on that project.
It's a loaded question. I'll do the best I can. So on the one hand, the document that the planning board is going to, the document that the planning board adopted in June of 2025 is the housing element fair share plan, which is an element of the master plan. That's going to be amended this month, was it February 23rd, by the planning board, which will include 190 River Road as a plan mechanism. I think it would be helpful to go back to how that site evolved, as a component of this plan mechanism, how the developer, came to own the property, et cetera. So my recollection is that Wells Fargo had occupied this existing three-story office building up until about 12 or 18 months ago. The site was put up for auction, and the winning purchaser was Onyx Equities, who was a partner with Russo Development. And so they were the team that at first came to the city exploring medical office, and that evolved through this fourth round affordable housing process, which created the opportunity for developers to propose projects like this to towns, to come to the city with a 250 unit project. That development at that time was perceived to be too intense, and so there were initial preliminary discussions, as all towns were engaged in, to see if that development could be reduced in scale in any manner. And so there were several iterations from there. Ultimately, when the planning board adopted the plan in June, the project had not made its way into the plan at that time and had not been reduced in scale enough that the city deemed it acceptable. There were a few public meetings, at least one where Russo's proposal at the time was vetted by the public. I think that was at the planning board, and the public was able to give feedback. And based on the feedback, the project was not placed in the plan. Your question pertains to, whether or not the proposal that is included in the city's agreement is, we'll call it consistent with the master plan. So on the one hand, the process that the state created basically says, what was designed to circumvent zoning, was designed to circumvent certain master plan provisions that municipalities have that, basically establish the character of the municipality. So I think there's a few ways to look at this. One is that you had an existing three-story office building that was atop of 2 levels of structured parking. And it was the developer's intent to remove the office building, keep the structured parking, and build on top of that. And so one of the key points of the mediation, as expressed by the court adjudicator as well as the program judge, was, hey, you have this developed site, it's got 700 parking spaces. This developer has a fairly legitimate case as to why they should be developed with some number of affordable units, and we worked on what those number of units should be. Furthermore, just under the site is, I don't know if it's a tributary to the Passaic River or some water body, that the site could not be demolished and redeveloped into something new. People had asked, why not just knock it down, build a nice townhouse development, build something else? The fact was that because of modern environmental regulations, you couldn't do that. You couldn't just bulldoze it and do something that would be more in keeping, with the character of Summit. So I would say that the current iteration of the project, as shown in the settlement agreement, the 198 units was just part of the mediation process, and again, it was guided by the adjudicator's comments, by the program judge's comments, and it was also an opportunity for the city to locate significant, well, I'll say some amount of density in an area of the city that might be less impactful than other sites and other developments. For instance, an 8-story, 300-unit project right in the middle of downtown on the Village Green. So again, when one had to make choices of, you had to do something, right? Doing nothing was not an option, because if you did nothing, you would lose your immunity, lose control of local zoning entirely. So we had to do something, and choosing from the different options we had to work with, that became a site that not only the program told us we had to work with, but again, once we understood that, we said, okay, how can we make this something that fits with Summit and that we can maximize the opportunity to maximize affordable housing credits and get other community benefits, like as discussed, $1 million, the Shunpike site, etc. So it, as proposed, it may not perfectly align with the master plan, but again, I think the site evolved through rounds of mediation, certainly a few heated conversations, between the city and the developer to get where we were. And again, remember, they started at 254, the final product is 198. And when you consider the Russo project and the Shunpike projects as a whole package, which it is, that represents a total of 223 physical units, whereby the city is going to get 95 affordable housing credits. So the ratio essentially is that the city will get 46.6% affordable housing set aside out of this 223 unit project. So from that perspective, it's a tremendous deal that alleviates development pressure elsewhere in Summit. That was part of the decision.
Thanks for that. We'll be exploring that in the liaison to the planning board, so we'll dive into that, I'm sure. But just on that project, it seems that it's a traffic highway.
All right, so they're going over their affordable housing presentation still. We're still early in the meeting in terms of what's on the agenda. So we're right here. And the first thing I get to speak about is right here. So it turns out that they fired the city solicitor. That's what I understand this as. Under finance, it says, amend professional services agreement 2025 city solicitor. Additional fees, $18,500. And there's a new city solicitor here. So they fired the old one. And there would be no reason to do that, other than the fact that there's this political party, conflict amongst those on the council. Here in Summit, there was a Republican majority, and on January, whatever the reorganization meeting was, January 4th, the new members were sworn in, and it's now a Democratic majority, and we have a new council president, Claire Toth. So, just give you guys a little update on all that.
The impact on taxes is not considered as part of the negotiation process or our own strategy.
I mean, all of those arguments are always made. If you go back and look at the Mount Laurel decisions, the Supreme Court and judges continually say that doesn't matter because that's what Mount Laurel did with its exclusionary zoning, was for the purpose of excluding school-aged children and keeping the property taxes low. So that's not a viable, and I'm not saying it's an excuse. I think it's perfectly legitimate, and I think that that's silly not to take those things into consideration, but they are not taken into consideration because of the Mount Laurel one decision. So,
By the judge.
by the judge.
Right.
So
But for our own
we can,
purposes.
I know that, I'm sure that Russo will show, traffic studies and school-aged children studies and all of those things, when they go to the planning board. There are more public hearings to be had, throughout this whole process, so, I believe that they will submit all of those things to the planning board when they come for application.
Thanks, you've been very patient. One last question. What is the total number of units expected to be constructed or potentially constructed with all of the mechanisms? And what would be the total number of new residents or occupants of those units?
Give me 1 second.
Council President, while Ms. Holm is looking for that answer, can I just elaborate on the question?
Please
That's
do,
what
City
it's for, yeah.
Administrator Bowman.
With regard to tax implications, I can't speak to the school, again, their budget and what they need to do and how many school-aged children might come in. So, development will give a presentation on that to the planning board on what they think it might be. But for the city, obviously, that would be a rateable, and we don't have a pilot. There's no pilot being considered for this. So that's where the county comes in and they get an extra 5% if we're giving a pilot. So there's no tax break given to this developer for this project.
If you prefer to answer that offline, that's fine.
Yes, I'll get that answer to you. I'm sorry. We'll put it in the frequently asked questions.
Thank you.
Sorry,
No
I just didn't
worries.
have that calculated. I'm sorry.
Thank you.
I'm sorry, if I may, very briefly,
Yes,
my,
Mr. Saracen.
my back of the envelope math, it's about 430. Total
Units.
If everything were to come to pass, including building, at Bristol Myers Squibb, et cetera, so both the projects and the overlay changes were to come to fruition over the 10-year period, it's, I believe, over 430 total units.
And you could assume an average number of residents for those units encompass some number, right?
Yes, and, that's assuming that the overlay zones all get developed in 10 years. So they've been in place for at least 12, overlay since 2018. Yes, so they've been in place since 2018, and only 2 of them have developed. And one of them was a 100% affordable habitat project, and the other one did not develop with the overlay zoning. It was only 6 units. So, that's assuming if all of the overlay zones, which have not developed yet, are developed. So,
Did you have a question, Ms. Galvinson?
Thank you, Council President. All of my questions really have been answered so far, but I did want to clarify something
talking about when we're comparing the 20 affordable units at Bristol Myers Squibb and the 25 affordable units at Shunpike. The Bristol Myers Squibb site is inclusionary housing, is that
Yes.
right?
Yes,
So what would that be more like a total?
that would be a minimum of 100 units with 20 of them being affordable.
Okay, so the Bristol Myers Squibb site is getting 100 units, not 20, like total.
Minimum, yes.
Okay, sorry, thank you, I just thought there was some confusion there.
Yes. Yes, and the 25, the Shunpike would only be the affordable, supportive units, better supportive units.
Do we have other council questions? Yes, Ms. Saraceno.
Thank you, Council President, and I apologize for jumping in earlier. I don't want to dwell too far on what happened in the past, but I do think it's important for us to understand how we got here so that we don't repeat missteps of those who have gone before us. So I want to refocus briefly on this issue of the 25%. So there was, as part of the most recent amendments to the Affordable Housing Law, this 25% multiplier as a mechanism by which towns could try to reduce the number of affordable housing units that they would have to build over the 10-year period. So on this question of whether our interpretation of the 25% rule contributed to Fair Share bringing their challenge against us, I pulled up Fair Share's challenge, and it says in part, quote, "The city self-servingly misinterprets the requirement to address at least 25% of unmet need through redevelopment and fails to meet the requirement." So this was the prior council's decision to apply the 25% multiplier to the much lower RDP, the realistic development potential of 18, I believe, rather than the much higher unmet need number of 327. So this was a choice that we made of how to apply the 25% multiplier, and based on what I'm reading in the Fair Share challenge, it does indeed seem to have contributed to the challenge that was brought against the city, but appreciate your thoughts if you take a different view.
Sure, yes, of course, they, just like anyone bringing claims against someone, you have to bring all of them or you waive them. I'm going to read the language specifically from the statute. Any municipality that receives an adjustment of its prospective need obligations for the fourth round or subsequent rounds based on a lack of vacant land shall, as part of the process adopting and implementing its housing element fair share plan, identify sufficient parcels likely to redevelop during the current round of obligations to address at least 25% of the prospective need obligation that has been adjusted, and adopt realistic zoning that allows for such adjusted obligation or demonstrate why the municipality is unable to do so. And the language that is important is to address at least 25% of the prospective need obligation that has been adjusted. That has been adjusted is the realistic development potential. That is the strict construction of that. My law firm represents 100 municipalities across the state, from Cumberland County up to Bergen and Passaic, and we use that interpretation all across the state. Like I said, I have settled cases where using the interpretation in Summit's housing element and fair share plan. Just because Fair Share argued it doesn't mean that they're right. We have no adjudication on what the statutory construction means. Several municipalities tried to file motions to have the vicinage judge review that language before we went into mediation, and they were all rejected. So it's basically left up to appeal to go through the system after plans have all been adopted and can appeal certain decisions. So no definitive ruling has been made on any of those, and there are varying interpretations of that. There's at least 4 separate interpretations that people have used across the state on the 25%. So just because Fair Share says it is what that is, doesn't make it so.
Thank you. Just one additional question. So based on the timeline that you set out during the presentation, we received our prospective need number from DCA, the number of new affordable housing units that were estimated to be needed over the 10-year period of 345 new affordable housing units, right? So that, to me, kind of set the ceiling of the number of new units that we would be obligated to provide over the 10-year period. As a result of the June 2025 plan, the reflection of the application of the vacant land analysis, that number then came down to 18 as the RD, the realistic development potential, and looking at what land is available and developable. So we went from the ceiling of 345 and then came down to 18. But then based on what was approved by the prior council in December of 2025, it appears we then came back up to 345 and acknowledging that these are not all new units to be constructed, right? A large chunk of them are for the rehabilitation of the Senate housing units, but we went from the ceiling of 345 down to 18, and now we're back at the ceiling of 345. So I guess my question is that I can't make that make sense really as to how we started and have ended up back at the ceiling.
Sure, so, the 345 is our prospective need obligation, and just because we had adjusted our number down using the vacant land analysis doesn't mean that the entire 345 goes away. It gets divided into the realistic development potential, which was the 18, and then you still have to provide mechanisms as the city develops and redevelops to try to satisfy that unmet need. That's where the overlay zones come into play for the prior round and round 3 vacant land analysis, and then the same is true for this round. And I don't know if it was as articulately stated as it should have been when I went through this, but what you'll see is if you go and look at the June plan, a significant majority of the mechanisms that are in the current settlement agreement were also applied to the unmet need. So you can go back and see the housing authority units are there. The hold on one second. So what was included in the unmet need last round, Harmon Holdings units, Glenwood Place, Weaver Street, Vito Gallo, MPC overlay zone, our house, Brandywine, and then what we did was we combined the unmet need, all of the mechanisms with the unmet need for prior round and round 3 and round 4 to make a combined unmet need. I don't know if recall what I answered a question before. For towns that have an RDP of 0, they would just, and let's say they had a 20 unit obligation, right? And they continue to have an RDP of 0, that 20 would just get added on to their unmet need that they already had, if that makes sense. I hope I'm making sense. So what you'll see is all of the ones that I listed are still in the round 4 plan. We've got our house, Brandywine, Harmon Holdings, MBC zone, Weaver Street, Glenwood, Vito Gallo, and the vacant and abandoned properties. So, and then we added the 5 new mechanisms. Based on the number of credits we had, based on the fact that we could utilize up to 87 bonus credits toward our round 4 obligation, it made more sense, particularly because we could not settle an incline to satisfy our entire obligation in order to move forward the process. I hope that answers your question. If you have a follow-up,
It does,
please.
yeah. I think just the categorization of the units matters right across the RDP, the realistic development potential, unmet need, and prospective need, because of the city's obligations vary, right? So understand that we had a large chunk of the units, I guess, allocated to unmet need in the the June 2025 plan, but they have shifted now. And like that's a serious change because now the city's obligations ratchet up.
Yes.
Because they have been recategorized, understanding that the total number is still there, but the allocation across the different kinds of units has changed, which means Summit's obligations to actually make good on these commitments for 345 units is greater than the position that had been taken in the June 2025 plan.
Yes, and just to reiterate, just because the city calculated its realistic development potential at 18, doesn't mean that Fair Share is gonna say, oh, this is great, we accept that. Rick, did you have anything in Fair Share in any town, or when you were calculating?
First of all, Fair Share challenged over 400 municipalities and every single town that did a vacant land adjustment, just based on the concept that you've reduced your obligation by some amount, right? Even though it's baked into the law that they might have helped, right? They were opposed to just the general concept of towns using that mechanism. So what was interesting is that throughout the mediation process that we had these three challenges, the RDP address actually wasn't attacked at all. And stand by the math, it was done accurately, and it didn't become a sticking point at any point in the mediation process because they had nothing to object to, frankly. But beyond that, the issue that we wrestled with was that we still had to deal with that matter of interpretation that was discussed. We had to deal with two live challengers that had, one had an option on a property, one owned the property, that was the Russo site, and we had to deal with them. So that was, what caused us to have to move off of the RDP. And part of the 345, if you go through the charts, were the existing credits that Nancy mentioned. I think 147 were Summit Housing Authority units, which, if you go back to the city's rounds 1 and 2 plans, were credited because guess what? They serve affordable housing, low and moderate income people, and they were taken out of the plan in the third round because that process was more of the Wild West. It wasn't conducted by CO anymore, and Fair Share Housing Center had an issue with the city's residency permit. So you had credits that were in the plan that were credited, they were removed, and we were able, through a lot of negotiating, to get those credits back into the plan. So that satisfies a huge chunk of the 345. So once we started putting these numbers together, as Nancy mentioned, plus 87 bonus credits, you could get up to 25% of the total number with bonus credits. It started to make more sense to just say, what do we already have, and put that all together. And that's what came together as part of the plan.
Council President, can I ask one more question? Sorry, just want to go back to Sean Pike for a moment. If we had not accepted that land, what is it zoned for today, and what would a developer have required in order to change that zoning and put in apartments?
Right. So as it exists today, it's got a sign out front that's called the Sliding Creek Farm. Right? You notice there's a couple of structures there. There's some equestrian-looking equiment, maybe some construction.
I know
Well,
it's actually there today. I meant the zoning.
Well, I'm going to get there, try to explain what the likelihood of what could happen there, right? So a few years ago, the Prod 2 zone, which was the old Celgene East campus, was purchased by Onyx and partners who were a partner in the Russo deal. They went through the site plan process and got the new Kenview headquarters purchased, and they had other plans for the process, for that campus, which we don't fully know yet, but we expect there to be additional activity there. At some point in time, Onyx and that partner purchased this property. So you have a private entity who purchased private land in the city of Summit. We don't know what their intentions were when they got it, but obviously it was a strategic decision on their part. They didn't just buy the land for, to preserve as a farm. And through the mediation process, one of their principals told us as much. He said, what do you think? It's just gonna, remain stable or whatever, whatever it is, open space. So that, and frankly, one of the prior iterations of the Onyx plan before you turned into this veterans thing was, hey, we understand the city's position that we think we're doing too much at 190 River Road. How about we divvy it up? We'll keep the market rate units on River Road and we'll put our affordables there. And for a number of reasons, we can't do that. You can't separate them and have, all the market rates here. It's against the law, frankly. I think it's one of the factors. So we said that that doesn't work. But they got through the conversation, they decided to make it available in the city and said, you know what, we understand that you need a site for your veterans housing. We'd like to donate to you. And so it became part of that discussion, and that was one of the concessions that they offered.
I don't think that answers my question.
Oh, so the
Is-
zoning,
what is
I'm
it zoned
sorry.
for? Yeah.
I think it's in the R5 zone, which allows for single and two-family zoning. Again, so what could it be developed? If you went with an as-of-right project, that would mean single and two-family houses. Again, the developer, I don't think was intending on ever using it for those, but, a lot of things I've heard, well, what would compel the zoning board to have to approve residential development? Fair, nothing really. But the site could have been used as part of this process or subsequent processes to say, I've got another affordable housing site and with a much larger density. And so, again, it solved the problem of, one, finding potentially a spot for the veterans housing in an area that's where land is highly desirable. Some, obviously, huge demand to live here, where availability of land is scarce. So trying to solve that problem was a really hard puzzle. You had a developer who was willing to make this concession. And I think the city moving forward, again, we don't have a developer, we don't have a zoning plan, would move forward with a transparent process that would allow the community to help design and give considerable feedback in how it will be developed, how it will be operated, so that it fits.
And we have an excess of credits now, yes, for round 4?
Yes.
How many?
Yes.
Planned?
We have planned, in excess of 23 credits as of right now. And that's, I typically try to plan for excess credits because properties come and go, developers lose options, things like that happen, where you can then, you're not stuck holding the bag and now you're back in front of the court trying to justify that.
And hypothetically, if, let's just use Bristol Myers Squibb for an example, if for whatever reason that doesn't get developed, what happens at some point in the future when we haven't met our obligation or our agreement with fair share housing?
Sure, so, there is what's called a midpoint review, and that's done, July 1st of 2030. That's halfway through the 10-year plan, the 10-year, round. And, we have to report on all of the housing activity, above and beyond the monitoring that we have to do every year, where, Augusto has the honor of entering everything into the DCA system every year by February 15th. We have to report, we submit a report to the court and we make it available to the public on what projects are built, what the status is of everything else. And then at that point, Fair Share Housing Center can come in and file an application against us if they don't think that we've met our obligation up to that point. And other developers can come in and say, this is no longer realistic. It's a very open process. So that would be probably the first huge milestone. There are other milestones in the Fair Share Agreement on specific projects, Franklin Place and 180 River Road are two that we have a midpoint review that we're to report on the status of those projects and whether they've been built at that point in time, and then at that point we can exchange them for something else. So let's say those two projects specifically, if for whatever reason they don't come to fruition and Bristol Myers Squibb provides more than 20 units that covers that, we can remove those from the plan or we could find another affordable housing site.
And then my last question is just, is there a legal reason why the newly elected council members couldn't have been a part of the conversations after the election? Like, could we have signed an NDA and joined the conversation even as listening?
It violates attorney-client privilege because you're elected, but you're not sworn in elected officials for the city. And that's,
So there was no possibility to sign an NDA and join the conversation as an observer? Okay. Thank you.
Can we make it brief, please, Councilmember Pulaski?
Well,
I know it's asking a lot.
I have some follow-up questions. Tom, I think you said said fair share challenge 400 municipalities.
Over 400, yeah.
How
Almost
many-
every town.
440, I believe.
How many municipalities are in here?
567.
And how many are immune to this process?
62 urban municipalities.
Yeah.
42, 62, somewhere.
And they're not necessarily immune to it, they don't have a prospective need obligation, they have a very high rehabilitation obligation. So they still have a Mount Laurel obligation, it's just to rehab units rather than, provide new units. They can if they want, but they don't, it's a different.
So most.
All municipalities in the state, according to Mount Laurel, to have an obligation, whether it's, if you're an urban municipality, it's rehab. If you're a suburban municipality, it's rehab and new construction,
But most municipalities are challenged.
all of them.
Did ultimately putting 345, our entire unmet need in our plan, close the door on additional challenges?
Yes, it did.
I had asked, did settling for the entire 345 unmet need close the door, ultimately agreeing to the 345 number, did that close the door on additional challenges?
Yes, it did. Judge Miller recommended to the business judge that Incline's challenge to our plan be dismissed.
And how many units did Incline allow?
It varied, I believe about 250 units on 1.8 acres.
And how many stories?
It evolved. So at one point it was eight stories, 300 units. Final iteration was maybe 225 units on 6 stories, but even that fluctuates.
Still doing this presentation. All right, let's go outside for a minute and have a cigarette while they're doing this. Let's just go outside for a minute while they're doing this. So just got back from Summit, or no, I'm sorry, got back from Cranford. I'm in Summit now. You know what's so funny? Since I was pulling another double header, I had like Summit's public comment on my mind when I was driving to Cranford, and I started driving to Summit. And I was laughing to myself, thinking that could only happen because of doing the double header, just driving to a different town. But luckily, they're close. But yeah, this presentation is mad boring, and it should be over in a couple of minutes here. But I need a cigarette.
I don't know that number, do you know? There were quite a few that did, but I'll say that we looked at the factors, the methodology, and then when that number was assigned
All right.
by DCA, I think it was November 2024, we looked at the opportunity to possibly reduce it then. And really
It's cold, and I didn't even bring a jacket.
as far as attacking the methodology, so we accepted that the state did their math correctly. They did some numbers, 345.
Yeah, I got to address a couple things with the council president tonight. Violating the First Amendment on her Facebook page by shutting off comments.
My perspective, it became let's make a deal that fair share housing sales.
You know that naggy First Amendment thing that they always want to forget about? That naggy First Amendment that they got to follow?
Yes, there are at least 4 interpretations out there. We use the strict construction
But yeah, so Cranford went super well. And Will's performance was great. It came out really good.
And how was that analysis?
I had a flag in the back. I was doing the throwing of the flag. I swear those meetings are so fun in Cranford. Yeah, Will was great. Will was great. He's always good. Oh. Thank you. Thank you, Ronnie. Yeah, I had no idea what I was going to say until I got up there, but that's how I do it a lot. Those are my favorite public comment moments, when I have no idea what I'm going to say, and then I just get up there and just let it rip. But I made my point because they're not there to answer questions. That's not why they're there. They only allow they're not even allowing, I can't use that word. They legally have to make a public portion available, but they don't intend on answering your questions. And that's not good for government. That's not good for local government. It's so bad for community involvement and engagement. I mean, there is none at that point. And then you sit down and they don't even answer your question. That's the other thing. So it's like, well, why even go? You wonder why a person gets to a point where they just ignore them and play music. Like, people don't really think about that, do they? You know, when I spoke to Will on the phone the first time, I'd already known he'd been going to meetings for years and years and years, and they weren't answering his questions. I was watching his videos. Why am I locked? I'm literally locked. This is great. I'm locked. Look, they locked me out. Look at this. Pick up the police phone. Pick up the, it's not even ringing. I got the red phone. Like, come on. There we go. Now it's ringing. Hi, I'm at the front door. I just stepped out for a minute. I'm attending the council meeting. The doors are now locked. Thank you. Bye. All right. Gives me something else to talk about. I step outside and I'm locked out. Well, at least I got that on video. At least I documented it. I'm at a meeting and they locked me out. So, wouldn't be the first, wasn't the first, it's not the first time this has happened. It's never happened here. I don't know why that door's locked. Could you imagine if public comment was right now? And I was trying to get up there. And not for nothing, but the police station is inside here.
Come on in.
Hey, Sarge. How are you?
I'm good, how are you?
I'm good. Why did they lock the door?
They locked at 10 p.m.
Oh, is that what it is? Thanks.
One more, Ms. Luceris,
Thank you, Council. I'll put myself on the clock. My daughter left This one, again, I apologize, but I do want to make sure that we learn our history. So with respect to, again, this 25% multiplier, you mentioned that there were 4 different interpretations. With the interpretation that was adopted by the prior council, then we went from 345 new affordable housing units down to 18, and then with the application of the 25% multiplier, we went down to 5. If we had applied any of the other interpretations, could we have gotten a lower number, or was 5 the lowest number that we could have gotten based on the 4 prevailing interpretations?
I don't think it was 5 at any point. What the 25% represented was 25% of the 345. If that, oh,
No.
actually, that goes to a number of different interpretations. So the 5, I think you mean, was the 25%
RDP.
of the 18, right, on top. Fair Share's position was that it was actually 25% of the unmet need. So the difference between 345, what we had at 18 at the time, 25% of that is what they indicated we would have needed. So even had we settled that, frankly, we had enough credits to probably make that work. We still had these challenges we had to deal with. And also recognize the need to get Summit Housing Authority into the plan so that they could be eligible for the fund.
And there were another interpretation was 25% of the total number, which never really made sense to me, but, that the 25% of the RDP is based on the fact that it says 25% of the prospective need that has been adjusted. It doesn't say it has been adjusted out, and that's the reason why, that interpretation was used. And like I said, that was my firm's position on.
And just another minute on that. So unmet need is a defined term in the revised third round rules, NJAC 5:97. It's defined. It says exactly what it is. It cannot literally mean what it says in the Fair Housing Act. It can't. So there's intention, and where people who were involved in the drafting said, well, it's supposed to mean that. Well, that's great, but it says this, and by the way, it cannot mean that by any stretch of the imagination. Be it as it may, we are where we are, but you also have to recognize the pace of this process, that the new legislation was enacted in March of 2024. Municipalities got their affordable housing numbers in October 2024, which were finalized in January. So you had between January and June then to develop a plan. I know it was always thought because this issue was ambiguous that there would be more robust debate and opportunity to discuss what it actually means. It turns out that nope, the program went full speed ahead and you had to decide where you were on the issue. And in the best interest of some, we decided that, well, we should amend the plan and minimize impacts, in the interest of the city.
Right, and unmet need has been a term that's been defined for at least 15 years, and so if the legislature met an unmet need, they should have used it, so.
I understand that the amendments to the statute were drafted inelegantly and open to interpretation, but it sounds like the answer to my question was no. We took what one might call the most aggressive interpretation of the law to get our number down, to make an attempt to get our number down from 345 to 18 to 5. And then we, through the process from October of 2024 to December of 2025, we dispensed with the legitimate mechanisms to try to get the number of new affordable housing units down to end up back where we started, right? We went from 345 and we ended up back at 345. How's the buzzer?
Council President, I have a follow-up.
Hold on one second. So, it was not the most aggressive. It was based upon the plain meaning of the statute. And that's what the Supreme Court would look at, and that's where the interpretation came from. The credits that we used evolved over time. Majority of them were already in our plan, whether they were unmet need or not. The intention was that Summit Housing Authority would get the funding that they greatly needed. There was no, has to be as aggressive as possible. Our RDP was adjusted using our court-approved presumptive densities from round 3. We used the plain meaning of the statute interpretation of the 25%, and we proceeded accordingly, knowing that we were going to be challenged by Fair Share Housing Center no matter what we did. We were going to be challenged by Russo, and we were going to be challenged by Incline. and we proceeded with this.
I have a follow-up question.
Yes.
Thank you, Council President. Back in June, what was the number that Fairshare Housing wanted? Was it 87 they came? Was that the number?
That their interpretation is 25% of the unmet need, which would have been.
Well, to be clear, we hadn't been in dialogue with Fair Share at that point in the process, but if you accepted their interpretation, the minimum number would have been 87.
The minimum number?
But again, that wouldn't have gotten rid of the challengers.
No, understood. So if you subtract 71 bonus credits, and subtract 147 credits for the Summit Housing Authority, and subtract 31 credits carried over from round 3, subtract 7 credits for the renewal of rent controls in existing housing, right? When you clear that all away, the actual number of new affordable units in this plan is 110. But if you go further, what you provided makes it clear that 23 of those are surplus credits. So at the end of the day, if the objective number for round 4 was 87 units, then 87 units is exactly the number of Fair Share Housing wanted us to agree with back in June in the first place. By starting at 18, we generated the leverage that was necessary to dictate how those units would be built. Had we capitulated to 87 on day 1, you go in to buy a new car and say, what's the sticker price? 60,000, I'll take it. It never happens. Had we capitulated to 87 on day 1, as some suggested, developers would have realized larger and more dense developments. And does that sound right? I know I said a lot, but.
Now, if, even assuming that we took Fair Share Housing Center's interpretation, which I do think is incorrect, that does not mean that Fair Share Housing Center was not going to challenge our plan. They would have challenged, 100% would have challenged our plan. They did in every municipality, regardless of whether, particularly as Tom said, in vacant lands, adjusted towns. I have one out of 20 that did not receive a vacant land, that did a vacant land adjustment that Fair Share did not challenge. Every single one did. That doesn't mean that Fair Share thought our RDP was correct. That doesn't mean that they weren't going to challenge us to increase the overlay zones or anything else, or to try and generate more additional units. So even if we had used Fair Share's interpretation of 25%, we were going to be challenged by Fair Share.
Exactly. So even if we started at their 25%, their 87, we would have been challenged, and we probably would have had more units, right? Because we started at 87. So starting at 18, and then go through the process of negotiation, we ended up at the same number that they had in the first place.
Right, and there was a justification for the 18. That was our court-approved presumptive density when we calculated our RDP the last time. And that took into account changes within the municipality at the time. We identified the Russo site as contributing to our RDP along with other sites. We created a reasonable RDP for the city.
Yeah, thank you, because it sounds like to me, if you started at 18, they wanted 87, we ended up at 87. That's like good negotiation to me. But anyway, thank you, Council President.
Are we there? Okay, thank you. I know we've had city staff waiting for quite a while. Luckily, the business portion is going to be very short. I say we call a 5-minute break and stretch. We'll be back at 10:22 and see how fast we can get through the business portion.
Madam Stewart.
Nice to meet you.
No, not a problem. Just tell me a little more about your role.
All right. Presentation's over. Questions and answers are over. So it won't be too much longer. It won't be too much longer till public comment, guys. And then we're gonna let it rip for our double header here in Summit.
In theory, yes, but I also learned so much more about the situation with the. So it was.
Yes, Rami. Tuesday night doubleheader. All right, so the rest of the meeting is short, so public comments will be coming shortly.
I saw that on the agenda, so it's the.
And then after that, I gotta get something to eat because I'm starving.
Oh, it's so. Got it.
I am hungry.
Why don't you go?
Okay. Right, I realized they could use the garage up to mine, but yes. Okay,
Okay, you need a raise. You need a raise.
Okay. Yeah, I know. I got lucky on this one. So I really, I probably I was fine, but I just had a city meeting. Oh, and I'm rather interested. So I tried to call in, but I was here. Okay. We're looking, well, I called the same number back. And I went so, yeah, they're doing so much. And safety for me is one. I think about some of the spaces kind of directly around frequently there are cars that are sitting on either side. Right when you're trying to turn, there's a sign saying honk, nobody honks, and you hear kids screaming down on scooters. So I don't know if you can push button like flashing light kind of
What I know about you, you'll love
something, listening to indicate when there's someone in the crosswalk or approaching, or no, like pedestrians approaching the entrance exit of the garage, and push a button to alert that someone approaching. So things like that. Yeah, the crosswalk of Brighton Place and so on. Thank you so much. Good to see you.
We do want to know city staff.
I'll be here if you need me.
Lady wants to stay.
Stay here.
I'm staying.
I don't know if it's hiding in the back the whole time.
I know, it's weird, so things like
No.
Okay, we have no ordinances for introduction this evening, so let's go straight to resolutions. First up is Councilmember Landman.
Thank you, Council President. For the sake of clarity and with permission from the clerk, I'll speak about both finance resolutions together and then we'll vote on them separately. These resolutions are related to the increase in legal services in 2025, litigation, property sale negotiations, labor issues, and reviewing Oprah requests drove up the expenses above what we had budgeted. The city originally approved a budget of $250,000 in December 2024, then increased it to $350,000, and then we need an additional $18,500 to cover the legal services for 2025. We have two resolutions. The first is to transfer money into the account we use to pay our legal bills, and the second modifies the contract with our law firm to allow us to pay for their services. So with that, resolution number 12390 authorizes the city to transfer $18,500 from the finance salaries and wages account to the legal contract services account to cover the additional legal expenses incurred in 2025. I move to adopt this resolution by roll call vote.
Do I hear a second?
Second?
Okay, do we have any comments from the public and starting with our residents? Comments from other members of the public? Comments from council? All right, then, Madam Clerk, would you please call the roll?
Mr. Moyer?
Aye.
Mr. Christopoulos?
Aye.
Ms. Counselor?
Aye.
Ms. Landman?
Aye.
Ms. Saraceno?
Aye.
Mr. Blaski?
Aye.
President Cook?
Aye. Councilmember Langton.
Resolution 12385 authorizes the city to add $18,500 to the 2025 contract with Cleary Giacobbe, bringing the total contract for 2025 services to $385,500. I move to adopt this resolution.
Do I hear a second?
Second?
Do we have any comments from our residents? Comments from other members of the public? Comments from council?
Council President,
Yes,
I'll-
Councilmember Boyer.
I will be quick. I just want to make a statement that all of these legal fees for affordable housing, for some of these lawsuits, and, I mean, that could pay for a lot of units being rehabbed. $365,000, upping the cost for our legal fees. And that's it. We're good.
Okay, these legal fees are not for affordable housing, is my understanding, Councilmember Boyer. But,
Well, these are Jacoby's, right? But the
Yes.
ones prior to that was, right?
This is all Jacoby's.
Well,
All Jacoby.
Okay, thanks.
Okay. All in favor?
Aye.
Opposed? Motion carries. On to capital projects and community services, Councilmember Christopoulos.
Thank you, Council President. As chairperson of the Capital Projects and Community Services Committee, I will introduce tonight's resolutions for consideration. The first is resolution number 12388 to amend the professional services agreement for the 2025 Affordable Housing Planner Services, additional fees in the amount of $7,000. This amount was already budgeted in 2025, and this approval would close out last year's bill for services. I move to adopt the resolution.
Second.
Comments from our residents? Comments from other members of the public? Comments from members of council? Okay, all in favor of this resolution? Opposed? Okay, back to you, Councilmember Crisafulli.
Thank you, Council President. The second resolution is number 12325, to authorize a grant application submission for the 2026 Sustainable Jersey Grants Program and to the PSEG Foundation to purchase an EV charging station for the back lot at City Hall, to hopefully move forward with the component of the Summit Community Energy Plan adopted by the city under Resolution 40951 on December 5th, 2023. I move to adopt the resolution.
Second.
Any comments from residents in the audience? From other members of the public? From council? Yes, Councilmember Pulaski.
Yeah, I just want to say I'm glad we're getting charging stations. It's going to be really important that we have some of these for our infrastructure going forward. And it's my understanding that if we were to put some solar on some city buildings, then throw in some charging stations as part of the deal. So just want to reiterate that we ought to be looking into that.
Thank you. Other comments? All in favor?
Aye.
Opposed? Okay, Councilmember Crisafulli.
Thank you, Council President Hill. The third and final resolution under CAPS, Capital Projects and Community Services Committee, is Resolution 12371 to appoint a part-time plumbing and mechanical subcode official. The closed session discussion approved the routine hiring of a replacement for a city official who retired in December. I move to adopt the resolution.
Second.
Any comments from our residents in the audience? From other members of the audience? From members of council? All in favor? Opposed? Okay. Community programs and parking services, Ms. Calvinson.
Thank you, Council President. This is resolution ID 12376. This resolution authorizes the execution of a revised agreement with Park Mobile. The agreement originally awarded to Park Mobile on December 2nd, 2025 contained provisions that were not agreed upon. Park Mobile included a line item stating that the city would pay an additional 5 cents per transaction in addition to the 35-cent transaction fee paid by users. This provision has been removed from the agreement and a vote is required to authorize execution of the new agreement. I move to adopt this resolution.
Second.
Any comments from residents? From other members of the public? Comments from members of council? Okay, all in favor? Any opposed? Back to you, Ms. Galvinson.
Thank you again, Council President. This is resolution ID 12377, and this resolution authorizes the submission of the grant application to New Jersey Department of Community Affairs Local Recreation Improvement Grant Program and authorizes execution of the grant agreement. The city is applying for a grant of $75,000 to update the aging playground equipment at Memorial Park Playground. I move to adopt this resolution.
Second.
Any comments from our residents? From other members of the public? From council? All in favor? Any opposed? No. Safety and health, over to you, Councilmember Pulaski.
Thank you. Let's get to the right page. Okay, this is resolution 12375 to authorize the execution of IT services agreement with QuickTex for the police department. Our law enforcement uses an IT management program, and I guess our last agreement has come due. We put out I guess we got 9 bids on it, and Quick Tech's won the day. So I move to adopt this resolution.
Second.
Any comments from our residents? From other members of the public? From members of council? Yes, Councilmember.
Council
Pacino.
President, it's an IT contract for the police.
Mhm.
And making sure our basic systems are working well, I think is really important. Just a quick thumbs up or thumbs down from Chief Peters. Is this a tender that you'd like to continue with?
Through you, Council President. Yes, as a matter of fact, QuickText has been our IT vendor for the last several years. The fact of the matter is, actually, they've been getting paid through our contract with Mountain Valley Emergency Communication Center, which is a regional dispatch center, which is a new province. You guys will be hearing a proposal on possibly moving that dispatch center back to Summit at some point over the next 12 to 18 months. So in anticipation of that, it was in the best interest of everyone for us to now acquire those services and pay for them directly before that contract is up. That being said, QuickText is also the IT vendor for the city of Summit as well. So we did go, they are not on state contracts, so we went out to bid through a request for proposal. I think Councilman Pulaski was correct when he said we had 9 responses, and QuickText came in as the most cost efficient. And again, they're very familiar with our systems. They work with us regularly for several years, so we're very comfortable with this contract. Any other questions?
Thank you. Any other comments from council? All in favor? Any opposed? Back to you, Councilmember Pulaski.
Thank you. This is resolution ID number 12393 to appoint a new police officer. We interviewed a fine young man named Marvin's Valerie. He'll be coming to us from the Irvington Police Department. He's, like I said, an impressive young man, and I think we're lucky to have him. The mayor and members of the safety committee all like him, so do the police, and we think he'll fit in very well here in Summit. With that, I move to adopt this resolution.
Second.
Any comments from our residents? From other members of the public? From members of council? You look eager, Mr. Boyer. Am I misinterpreting it?
No, I was just gonna say that, those Essex County, municipalities better be careful because we're taking all our police notices in New York and these aren't police out there. So I told the secret, Peters.
Any other comments? All in favor?
Aye.
Opposed? All right, then I believe city staff, you are reading. Oh, they have certificate.
No, they don't have to.
No? Okay. Okay, well, let's move on to the consent agenda. Hopefully this won't take long. Do I have a motion to approve the consent agenda as presented?
Council President, for the
Yes.
finance part, do we have to take a roll call vote on that?
No, we do not.
So moved.
Second.
Okay, thank you. Any comments from our residents in the audience? From other members of the public? From members of council? All in favor?
Aye.
Oh, I'm so sorry, Ms. Kalmanson, you were about to say something?
I was, it was just a quick, for anybody who was looking at the packet for the permissions granted, there was a typo in the Juneteenth flag. It said June 19th through, I think it said 1 or 11, and I clarified with David Rita, it's June 19th through 21st. So if anybody's looking at those and wondering when the Juneteenth flag is going to be up, those are the dates.
Okay, thank you. So, all in favor?
Aye.
Opposed? Okay, thank you. And good night, city staff. Thank you for waiting it out. Okay, so at this point in the meeting, members of the public have an opportunity to comment on anything. And I'd like to start, if we have residents who'd like to make comment. And remember, we've got a 3-minute limit. We do have a resident waiting to make a comment, sir.
I'm a resident.
No, okay, we're not doing this. Come on, you have to do this fast.
Sir, the request is just that residents go first.
Can you back or can you please just give us?
You can leave, go ahead.
What I need to say is you can ask and I'll honor your request.
Would you please allow the resident to make her comment?
I always let residents go first.
Thank you,
So you
sir.
ask, it's not enforceable, that's the whole point. Thank you. Of course, you can have residents first. I always let them.
Just for the record, that is the councilwoman's request, that residents be offered the opportunity to go first and then other members of the public.
Thank you. Tracy Keegan, I've been a resident of Summit since 1994. Excuse me, I moved to Summit first in 1994, been back and forth. The Round 4 plan resulted in the most serious challenge Summit has faced in decades, one that will shape our town for generations. And for the last 2 years, council was controlled by Republicans who put Summit at risk. So to Mayor Fagan and the Republican majority, from last year, this outcome did not happen to you. It is happening to us because of your decisions. So that excuses your accountability. If you trusted the lawyers without question, why? And if you believe they were giving you bad advice, why didn't you fire them? There are over 500 municipalities in New Jersey. Many are run by volunteer councils. Many are run by Republicans. And yet only 16 towns had their immunity challenged in the way we did. Even my beloved hometown of New Providence, Republican controlled for decades until last year, we were elected one Democrat, managed to comply without being sued. You now blame Democrats in Trenton, but Mount Laurel has been settled law since the 1970s and is cemented in the New Jersey Constitution. Disagreeing with the law does not excuse ignoring it. You had years to plan. Instead, 3 of you went to Trenton and made outrageous statements that made national news. For 2 years, you held the majority. You had inside information. You spoke with developers. You knew the risks. In June, you gambled on a plan so aggressive and flawed that Fair Share Housing dismantled it. An improper vacant land analysis, double-counted units, ineligible credits, basic math errors. By December, you reversed course and abandoned the vacant land analysis you relied on months earlier. And now we're looking at several hundred new units. You removed the residency preference for our housing authority, pushing aside Summit families and seniors who have waited their turn. You are using the Affordable Housing Trust Fund to pay for renovations that could cost many times more, while hurting the very families that we should be protecting. We know you guys know how to raise money. You raised $1 million for Tatlock overnight. But instead, you traded the Summit residency requirement for $1 million for Russo, which won't anywhere near cover the cost, $175 per unit. $1 million divided by 175,000, what does that get you? We all remember what you said while you were still in the majority, that you worked hard, that the community would be pleased, that you protected Summit from irresponsible growth, that builders remedy warnings were fear mongering. Those all turned out to be empty promises. So don't hide behind lawyers, don't blame Trenton, don't blame your Democratic colleagues who were either in the minority or not even elected when you created this mess. If this was the best you could do, it's malpractice, and Summit deserved better.
Thank you. Any other residents?
It's quite painful. Carol Paxton, 234 Summit Avenue. By the way, I will be reaching out to the city clerk because I think I have a invisible, I have an invisible disability of long COVID and staying asleep, standing to speak, and the lighting in here is quite difficult to deal with. So I came to thank those folks here that came to our vigil at St. John's Church the other week, including President Claire Toth, Michelle Hansen, Jackie Saracina, and also Assemblymember Vinnie Carney also came to our vigil. Past council members, including Marjorie Fox, Greg Bartan, Andy Winiger, and Susan Hairston also were in attendance.
I highlight these elected, past and current elected officials because I think it's very important that our community see that our elected folks are coming to support them because our residents are scared. I heard some quite alarming stories in addition to those that I've already heard of Summit residents being taken advantage of, intimidated and harassed by both ICE and also by lawyers that are coming to say they're helping residents deal with immigration issues, yet being taken advantage of financially in these situations. I really urge, we're gonna have some upcoming other events that are focused on action-oriented events and events to make our community feel safe. And I really urge all of you to try to be in attendance, and really am inviting you to come. Especially Mayor Fagan, I would really love to see some sort of statement made by you because our community members are very scared and legitimately so. And this is not political. This is about taking care of our community. This is about addressing the needs of our community. This is about protecting our community, again, which is all the things that you all are elected to do for our community members. And so, we are going to be planning multiple events that are focused on ways. I have had like 20 plus community members that have reached out to me personally, and that's just the N of one. Folks that have reached out to me of how do I help? How do I volunteer? How do I donate money to this effort? Because they are recognizing that our community is hurting. I would like to see that effort publicly being made by all of you in some way, shape, or form, because I think that really sends a message to our community that all of you are thinking of them in this time. That is very difficult for so many folks here in Summit that are being directly affected. And I think that would go a really long way towards our folks here in town feeling that you guys are addressing their needs. Thank you.
Thank you, Dr. Beckton. Any other?
Good evening, Diego Ford. Council President Coe, are you carrying a passport for your birth certificate today? How about you, Mayor Fagan? Councilman Ward, are you carrying a passport for your birth certificate? How about you, Chief Peters? Bob, Michelle, is anybody carrying any proof of citizenship today on their persons? You're all elected officials. I presume that you all know that we have First Amendment right to speak and communicate in whichever way we please, including, for example, speaking in Spanish, speaking in French, speaking in whatever language you want to communicate with each other, with our kids. This nation has had a very unfortunate history of racial profiling. Is that correct, Reverend Harriel? The reason I bring these things up is because the way immigration enforcement has been handled for the last couple of months is not just a threat to people who are illegally in this nation. Now, illegal immigration is a civil crime and it needs to be dealt with. Criminal aliens, of course, are criminals, they need to be treated as criminals. But we're right now in a situation where none of you carries your passports or your birth certificates for the simple reason that you're not afraid that somebody's going to ask you to show your papers, like it happened in Nazi Germany back then. We used to make fun of the scenes where people were being asked to show papers. Now, individuals who look the wrong way, who speak the wrong language in public with their kids, are being detained and being treated as guilty unless they can prove their own innocence. I want you to think about that for a moment. And for what? For the crime mind speaking in a different language to their kids? We've had Native Americans in the western states being detained on suspicion of immigration violations. Think about that for a moment. We have many of you have last names that are definitely not Native American last names. Claire's an example, Bob's another one, Michelle. So what happens if, say, whoever was Mr. Pulaski who came however many generations ago was actually.
Thank you, Mr.
I'm
Wright.
out of time, but think about that. Because we're actually having issues in the way citizens
Thank
are
you,
being treated.
Mr. Wright. Any other residents?
John Calabrese, Yale Street. I had something prepared to speak tonight. I'm glad nobody else is here. But I'm really hoping that this statement fosters more communication about what's going on at East Summit right now. So I'm here tonight to voice some concerns about the proposed low-income and/or veterans housing project at the former farm located at the end of Shumpike Road in East Summit. As with many people who spoke here tonight and at the last council meeting, my family has lived in East Summit for generations. My grandparents immigrated here from Italy during World War II and settled on Orchard Street. My father and I were both born and raised on Orchard Street. Our kids were born and raised on Orchard and Yale Streets, all a few blocks from the proposed project. To say I have a vested interest in East Summit is an understatement. East Summit has a certain fabric to it. The houses have a look to them. Some from the early 1900s, some from the 50s, 70s, and 80s. All 1 or 2 story houses with decent setbacks and backyards. This is what should be built on a former farm lot. Modest houses to match the fabric of the area, maintaining the same lot coverages, setbacks, and building heights as the rest of the Ivy area houses. Please do not shoehorn a huge multi-story monstrosity into our lovely community just to satisfy a state requirement so a developer can get top dollar across town. I do not mind low-income or veterans housing as long as it blends seamlessly into our neighborhood. I do think it's a little tone deaf that veterans housing be put within earshot of a gun range that is operating spring, summer, and fall. Please keep our community involved and updated as you can and before any permanent decisions are made. While I'm discussing projects in East Summit, I would like to ask about the status of Brian's Pond dredging project. Is it complete? What was the scope of the work? At the moment, it looks awful, half completed. Almost like they ran out of money and walked away. Any information would be greatly appreciated. Thank you for your time and everything you do for Summit.
Thank you, sir. Yeah. Other residents? Other members of the public?
Good evening, Mayor. Good evening, Council. I will be remaining anonymous. All right, so one thing I want to mention is tackle one issue. So one issue I want to mention is the Supreme Court in 2024, I believe it was, Lindkey versus Freed was a case that says the social media platforms, when you represent yourself in your official capacity, is considered a public forum. Ratcliffe, O'Connor versus Garnier is companies with that. It's another case. So Council President, I noticed throughout the week that you shut commenting on your Facebook, on your official Facebook page here. It's bad enough I'm getting Rosa Parks, getting back in it buzz. But I let residents go first anyway. So yeah, so you're violating the First Amendment by doing that. You have one post here, it says, talking about the live Q&A with the mayor. I welcome the opportunity to meet with residents and look forward to hearing your questions, concerns, and priorities. But not on the post, because commenting is shut off. You know, so, I mean, the way this would be fought out in court, in terms of, it's a public forum. So, when you originally allowed commenting, and then you decided that you're gonna shut them off, it becomes a liability issue for the town. You know, because you could possibly be held liable in court for violating the First Amendment. That's the way I would, if I was a lawyer, that's how I would argue it, because it originally was on. So, content neutral, viewpoint discrimination, oil and vinegar, they go together, but when you originally had it, you originally allowed it, and then you shut it off. We have another post here. Pick out a couple favorites. Live virtual Q&A. I hope you tune in, ask questions in the comments, but there's no comment on the post. So, you know, I think if it was to go to court, you would lose because you originally had it on. It was originally on. Then it was shut off. And it's not content neutral because you're doing that on certain posts where there originally was commenting. So I would do the right thing and restore the people's First Amendment right to address their grievances with government when they're representing themselves in their official capacity.
Thank you, sir. Do we have other comments from members of the public? Comments from council? Seeing, oh, Mr. Belowski.
Sorry. Okay, affordable housing, I have a few comments. So I see there's a bunch of folks back from the Ivy League again tonight. At the last meeting, people from that neighborhood seem pretty certain of two things. One, they were planning to build an apartment building. And two, that we were going to be voting on zoning. Just want to say that neither one of those were ever true. And whoever provided that information was ignorant of the facts. I'll just add that at least the reason that I pushed so hard to get that plot of land during our negotiations is to prevent the big apartment building ever being built down, and not the opposite. Second, on affordable housing, just want everybody to know when we're talking about transparency that there's a difference between what happened in round 3 and what's happening now in round 4. People on social media have been very critical of the process and the lack of transparency that we've had with it, and rightly so. We as a council have been hamstrung with what we can say. Broad Street West, to contrast, was a voluntary project. Council took it upon itself to make something happen there, try to make something happen there. We were told things like we couldn't possibly satisfy our round 3 obligations unless we do Broad Street West. And after changing the guard, the council rolled up its sleeves and finished off round 3 with scattered sites around the city. And we even ended up with a surplus to help us in the future. Then there came new legislation. Trenton created a judicial process called the program, confidentiality attached, and we couldn't share as much as we would have liked. This is not unique to Summit. Same calls for transparency can be heard across the street. Who's to blame? I'm sorry, Ms. Keegan, Trenton. And the affordable housing industrial complex. You see, public engagement slows down development and delays profits. And while it breaks my heart to have unwanted development forced upon us, the plan positions Summit well for the future, without, or at least with less of a specter of builder's remedy or such stout requirements going forward. 3, my third comment on affordable housing goes to Claire's statement, Council President Toth's statement on affordable housing. I didn't comment on it at the last meeting because I thought that others covered the points that I would have made very well, but a number of residents have asked me to personally share my views, so here they are. Given where we were in the process, I thought that the statement was unnecessary, if not reckless. Criticizing our initial plan in the midst of our negotiations didn't sit well with me. Council President Toth's statement that we are building 345 new affordable units was false. As Jim Bennett calculated for us and Councilman Boyer did again tonight, we're really talking about 87 new affordable units. The balance are credits for existing units or bonus credits for units for veterans, special needs, and the like. A third point on this, I keep hearing from my fellow council members a desire to develop a positive working relationship. And I think blaming the Republicans, which also was in that statement, for Summit's affordable housing woes is directly at odds with that concept. So is exchanging safety-related emails without copying the safety chair, as Calvin said. And so is changing up the historical minute without even telling the person who made it happen in the past couple of years. So is removing committee agenda items requested by a council member on that committee without telling them who's the Saraceno. And so is changing the Summit Housing Authority appointment without consulting all council members, or at least telling them. So I hope all the talk about wanting to have good relationships among all of the council is not just talk. And I look forward to fostering a more productive, cooperative environment going forward. As for the genesis of all the forced development, we all know who's responsible. You've probably seen riding the train from time to time, the big sign in Trenton that says Trenton makes and the world takes. And I say that indeed Trenton does make ludicrous legislation on affordable housing. And the developers in the affordable housing industrial complex certainly take, and municipalities choke. Maybe they should change their sign. We haven't talked much about the budget yet. And I know it's a huge lift and it's always a work in progress. I haven't gotten many updates, and I know, again, it's a long and complicated process, but I urge the Finance Committee to keep the uptown cameras on the safety budget. When I campaigned, I heard a lot of talk about technology. Technology is the future of law enforcement. We need technology. And technology costs money, but it's something that we've been talking about for a long time now, and I hate to keep kicking that can down the road. Strategically placed cameras uptown are an important piece of technology. Again, we've been planning them for some time. And God forbid, just imagine, fire call during rush hour while Maple Street is closed for outdoor dining. Don't we want our professionals to be able to identify the inevitable traffic jams before they leave the station? Another budget issue is the dog park. It was in a preliminary budget. I don't know if it's gonna make the final cut, but before that hits the cutting room floor, please read all the comments that we received. It was a big hit and it helped to foster new friendships and bring the city together. And my last comment is go see Big Fish at the high school, February 25th to the 28th. They put on a great show, and it's a great story. Thanks.
Thank you. Any other council comments? Ms. Lynn?
Thank you. I would like to address comments tonight from Dr. Pactang and Mr. Goik, as well as others who have reached out to me privately. Many of us are feeling unsafe and scared and uncertain about what to do. Upstanders that I know are afraid of calling attention to our city. Neighbors aren't sure how to talk to one another about whether they're in need. And kids are scared to come home to find an empty apartment. And, you know, amongst my family and friends, we are talking through various scenarios with our spouses and kids and evaluating scenarios of what would we do if ... Everyone has a different answer to those questions because we all have a different set of circumstances and responsibilities and risks that we're managing. But I want to say that if you or someone you know needs help, please reach out to us. We can and will share accurate information to the extent that we have it. We will connect residents to trusted legal and social resources and stand firm in protecting the safety, due process, and basic human rights for everyone who calls this city home. Thank you.
Other comments?
Council President.
Yes, Mr. Boyer.
So I want to take a moment tonight to recognize the real and meaningful win for this summit. Through the efforts of Congressman Tom Kane, federal funding has been secured for long-needed sidewalk improvements along Glenside Avenue. 2 years ago, we did some photos there with Congressman Kane and a bunch of neighbors, and last year it wasn't approved. It was about $500,000. $500,000. It wasn't approved last year, so the neighbors kind of lost hope a little bit, but Congressman Kane got the funding. This isn't a abstract policy. These are real sidewalks on real streets, serving real people in our community. What makes this especially important to acknowledge is that this support came despite years of political attacks aimed at Congressman Kane by local Democrats. And yet, when East Summit needed help, when Glenside Avenue needed an investment, he didn't hesitate. He didn't ask who voted for him. He didn't condition support or party loyalty. He most certainly didn't do that with me when I talked to him. He just said, Mr. Boyer, what do you need? But you know, sidewalks are not partisan. Public safety is not ideological. Infrastructure does not belong to a party. It belongs to the residents who rely on them every day. Here in Summit, our obligation is simple. Do what's best for the city. Do right by every neighborhood. We work with anyone, Republican, Democrat, or Independent, who is willing to put Summit first. And when someone delivers tangible results for our residents, especially for communities that too often wait the longest, integrity requires that we acknowledge it. So tonight, I want to thank Congressman Kane for the partnership and for recognizing the needs of East Summit. And by the way, if Congressman Kane was a Democrat congressman, I would recognize him tonight as well. If I picked up the phone, called, and he got $500,000 to put sidewalks on Glenside Avenue, I don't care what political party you're from. You're helping the people. Who cares? It's wrapped up in the politics. I know as a politician I'm saying that, right? can't stand it. Summit Housing Authority, real quick, because people would get up here and just say all kind of nonsense. So there's 48 units, residents, that we did not remove the residency requirement for in the senior building. Why? Because if you actually know Summit and know the people who live there, there is a transition that happens when you live on Glenwood or Weaver and you raise your children and they leave high school. The transition typically is you go to the senior building. We know that. I know that. So I'm not gonna let that happen, right? So those 48 seniors who are looking to get into the senior building, that's intact, didn't touch it. Now, the family resident requirement for Glenwood and Weaver, I don't know one person that's ever seen the waiting list. Nobody's seen it. I don't even know if it exists. I asked for it, didn't get it. I know commissioners who asked for it, they didn't get it. I know people who moved in to Glenwood and Weaver Street has never lived in Summit before. So to say we're not going to give you $1 million and all this other aid so that you can fix all the units up because of a residency requirement that you don't even know that's being upheld, that doesn't make sense. That doesn't make sense. I mean, listen, give credit where credit is due. All right, 195 units being rehabilitated. That's a big deal. We got to stop acting like it's not. That's a huge deal. There's one thing that I did up here. I would be happy if this happens. That means that I did my job, hooked up the place where I came from. What better responsibility than someone being on council, living in those areas, to now on council, to remember where you came from and make that a priority in your life. Bob talked about the cameras. I'm big on police and security. To not have cameras in a certain section of our town is irresponsible. That's been taken out of the budget. That is ridiculous. The dog park, listen, all you have to do is look at all the surveys for the dog park. In Summit, in the summertime, there's not a lot of people around, right? That dog park has brought many people like happiness. It was a meeting place. People would go there, they get coffee at the Village Green. Most people had bags, so it lifts up shopping. And the Village Green is supposed to be a gathering point, right? And how much does the dog park cost? $50,000? How much is our budget? 160 million? Is that something like that? All right. I think we can afford a dog park. So hopefully we can get that. So I hear gamble a lot. Like we've been gambling with the fair share housing. Just want to tell the public that people can get up here and they can say like whatever they want. It doesn't have to be true. You can say anything, right? That's how America is. Thank God we're Americans. So you can get up there and you can say just whatever you want. Don't believe everything you hear. Do your own research. Because I'm sorry to say, right? But people lie. They lie a lot, because a lot of this is about winning elections and it's about politics, but it's not about telling the truth. It is Black History Month, and I did have something written, but I'm not going to go through it all tonight because it's 11:12. But I will say that I want to give people a different perspective about how others think, especially Black folks. There is a professor, economist, Glenn Lowry. Last name is spelled Loury. First name is Glenn. Born in Chicago, 1948. He was the first indigenous Black American to be a professor at Harvard University, he's an economist. He has a YouTube channel. He brings a really different way of thinking, but it's very open dialogue. Some of his quotes: dignity is not negotiable. Judge policies by results, not by rhetoric. I like that one the best. And we can argue without hating. That's the second runner-up. I probably have a lot more to say, but since it's late, thank you, Council President.
Thank you, and I'm sure you'd want a larger audience. Do we have other council comments? Ms. Saracina?
Thank you, Council President. I will put myself back on the clock here. We are celebrating Kindness Month here in Summit, and this week we are encouraging people to be kind to our neighbors. Even just the simple act of saying hello to someone you don't know can boost their mental health and actually boost your own mental health. So more suggestions coming out over the course of the month. As has been noted, we are celebrating Black History Month, and I want to just lift up a really great opportunity. The Summit High School Black Student Union is having an art exhibit and fundraiser on Friday, February 20th at 6 p.m. in the Summit High School. Student contributed art will be available for display. It's just a suggested donation of $10, and the funds will benefit both the student union as well as the Make-A-Wish Foundation. So that's Friday, February 20th at 6 p.m. at Summit High School. Appreciate very much the comments that have been made this evening on immigration enforcement. Everyone spoke very eloquently, and I have been struggling to find adequate words with respect to what's going on in immigration enforcement in our country to speak to the fear and the loss that people are feeling, to speak to our need to protect the children of our community, to want to protect our neighbors and our local businesses. Because I think there really aren't adequate words, right, to speak to the moment that we are in. But as has been mentioned, there is opportunity for action, and we are taking steps, and we should continue to take steps to help our neighbors in whatever way is needed. So if you know someone who is in need, or if you are in a position to be one of the helpers of providing school supplies, groceries, whatever the need may be, please do come talk to us, and we will confidentially help to try to address the need to the best of our ability. Summit is a beautifully diverse community, and that diversity is a strength that we hold dear, and it is part of our job to protect it, and that's what we're here to do.
Thank you. Anyone else? Ms. Galvinson?
Thank you, Council President. Regarding ICE, I know a lot of the community doesn't feel safe right now, and what we're witnessing happening in the country is heartbreaking, and I understand why people don't feel safe. And that's one of our most important roles, is to make sure that our community is safe and our community feels safe. So we need to talk about this in the safety committee again, and try to identify some ways that we can make the community safe in this moment. I don't appreciate the accusations that we are not working with Councilman Pulowski. Last year, we were in the minority, and Council President Toth and I, we didn't know what was happening a lot of the time until the last minute. You know, I mean, information was gatekept from us, and there was a time when I got a phone call from Councilman Pulowski, and he was asking me what I thought about something, and I was thinking about it. I said, but my vote doesn't even really matter. You already have the votes, right? And he said, yeah. So, but so we went from a situation last year where a couple people felt like we felt like we were being kept out of the loop, and that nobody wanted to really inform us until the last minute about things. And now, I think it's a different feeling when you're in the minority, I guess. Regarding the dog park, DCP doesn't have those comments. Resident feedback, and I asked if they had them and they said no, so I'm gonna try to, get them from Aaron because I haven't seen any of the feedback.
I can't speak for anybody else, but Claire and Michelle, you know that I called you and told you about things and talked to you about things all last year.
Let's just put a lid on this for now. Thank you. Mr. Christopherly.
Just one last word, Council President, thank you. I really appreciate the comments about bipartisanship from Bob and from Janelle, and I won't get into a tit for tat on anybody's behavior here, but none of us is perfect on this front. I'm hearing it from residents all over Summit. I agree that we should respect each other, and we should stop making up lies that get repeated and amplified and repeated again and again and again, even from the campaign on social media. In terms of partisanship, there are voices that are trying to blame me as the new guy for this affordable housing settlement. On that point, we simply need to set the record straight. As we heard tonight, nearby towns that are similar to Summit took a different approach and had far more favorable treatment, and the residents enjoyed greater transparency and ability to make public comments. They were not blindsided as we've seen here in Summit. So that's really what I'm saying. I want to have bipartisanship, but it's a two-way street, and what's said by ourselves matters, and the way we conduct ourselves matters. Thank you.
So we can each move first to be bipartisan.
Council President.
Has everyone else made a first round? Yes.
I find it funny that we say, let's not be political and let's not throw stones, whatever. You made this whole speech.
Nope.
And then you just say, there were all these towns, Republicans messed up and blindsided and I mean, if you're gonna make a speech about not being political and nonpartisan, just make the speech about brotherly love. But then you throw daggers in the second half of the speech. It doesn't work like that. I think people have ears, they can hear.
Yep.
Like, just because you talk nice doesn't mean that you ain't throwing shots. Like, come on, man.
I'm just telling the truth, you know.
Thank you,
You
gentlemen.
just said that you weren't gonna lie, so.
Thank you, gentlemen. Okay, I am just calling council member comments closed. I am just gonna say, thank you for sticking it out as long as you have, everyone who is still here. This is a discussion, it isn't over. And do I hear a motion to adjourn? Second?
Second.
In favor?
Aye.
Opposed? Good night.
It is cold. I went outside before for a couple of minutes. I didn't realize they locked the door at 10 o'clock. I was locked out for a minute. I didn't know that.
Yeah,
Yeah.
they lock it. It's like, oh, usually we want to be out of here before that.
No, I get it. I get it.